One of the questions we get a lot from our business clients is either what is a letter of intent, or I need a letter of intent, or the other parties ask me to sign a letter of intent. And when we ask them what they're looking for, what we discover is most people don't know what a letter of intent is. So, what is a letter of intent? Hello again, everyone. My name is Tom Reilly, and today we're going to talk about something that's almost but not quite a contract, almost but not necessarily always necessary, and always confusing. They're called letters of intent. Essentially, a letter of intent is, as its name implies, a document where parties agree that they may agree to something in the future. Kind of like the substitute teachers of the contract world. No, Miss Substitute Teacher, we're not going to have a quiz today. We're going to talk about taking a quiz on another day when you're not here. And when you strip a letter of intent down to what it is, that's exactly what it is. It sets forth the current intentions of the party to maybe do a deal in the future, but if written correctly, doesn't bind either party to do anything with regard to the deal. One of the problems with letters of intent is, A, people don't always know what they are. B, sometimes they don't say what they're supposed to say. And C, sometimes people try to sneak things into their advantage that if you're not looking very carefully can cause you difficulty. Let's start with the first thing. Letters of intent by their inherent nature should be non-binding. That means we've kind of agreed to this, but going forward we may not. And if we choose to change our mind or decide not to do the deal completely, that's fine. You want to make sure there's non-binding language in the letter of intent. If you get a letter of intent that says this letter of intent is binding, that's not a letter of intent, that's a contract. If you sign it, you've agreed to the terms in that contract, notwithstanding the fact that it says letter of intent rather than agreement. Now there's the third wrinkle to this. Some portions of letters of intent are in fact binding. Not the substance of the deal you're negotiating, but certain things about negotiating the deal. These are things you also have to be wary of. Number one, there's usually a confidentiality clause. Both parties agree that neither party is going to tell anyone about the deal they're thinking about doing in the future. Number two, letters of intent normally have a due diligence or investigative period where the party, usually the party buying the business or the asset, has a certain period of time to look at things, review things, get more information from the party selling, and the party selling agrees to provide that information, subject, of course, to the confidentiality provision we already talked about. The third thing is the one that trips people up the most. Very often, letters of intent have an exclusivity provision in. What that says is that for a period of time, 60 days, 90 days, 180 days, 1 year, whatever the letter of intent says, you as the seller of the asset or the seller of the business agree not to talk to anybody else about selling the business or selling the asset other than the other party to the letter of intent. Very often when the bidder knows that there's other people interested in a business or in an asset, they'll attempt to get a letter of intent signed with an exclusivity provision in there. Why? Because they want to be the only person you're dealing with. Why? Because once they're dealing only with you for a period of 1 month or 2 months or 3 months or 4 months, your deal kind of takes on a critical mass. And now, even though you're changing the terms you agreed to as buyer in the letter of intent, the seller goes, I'm not going to worry about that because I just want to get this thing sold. So yeah, they're paying me $50,000 less. So yeah, I'm agreeing to this when they said they were going to do that. I just want to get this thing done and get out of it. Letters of intent are very often used for that purpose. So if you're the seller and you've got a buyer asking you to sign a letter of intent, make sure you read it very carefully. Make sure you have an attorney read it carefully to make sure what you're agreeing to is what the letter of intent should be. Essentially, an understanding about what you might agree to in the future and doesn't turn into something you don't want it to be. Locked into one buyer for some period of time, agreeing to other things you don't want to agree to, and most of all, make sure the letter of intent is non-binding. The letter of intent needs to say that because there's no definition of what a letter of intent is. It can be whatever the parties choose it to be. The words within the document are the most important. So that's letters of intent in a nutshell. A lot to learn. The most important thing is be wary. Read the document carefully and make sure it says what you want it to say, not what you think it says, because it says letter of intent. Thank you for your time. This time until we do it again next time.